Good day and welcome to Epstein Becker Green's webinar. We are experiencing a couple of technical difficulties, so I apologize for the beeping sound that you may hear during the introduction. This webinar is the 2016 Year in Review, Trade Secrets and Non-Compete Laws and Developments presented by Peter Steinmeyer, Robert Goldstein, and Jonathan Shapiro. Peter Steinmeyer is the managing shareholder of Epstein Becker Green's Chicago office and the co-leader of the firm's Trade Secret and Non-Compete Strategic Initiative. Robert Goldstein is a partner in Epstein Becker Green's New York office and devotes a substantial amount of his practice to non-compete restrictive covenant issues, including litigation, arbitrations, and providing advice and counsel to clients. Jonathan Shapiro is an associate in the Employment, Labor, and Workforce Management Group in the firm's New York office, and a significant portion of his practice is devoted to handling trade secret and non-compete cases. Before we begin today's presentation, please be informed that the webinar is being recorded and that participant phone lines will be placed on mute throughout the program. Again, I apologize for the beeping that is occurring, but the webinar participants are welcome to submit questions during the webinar, and the Q&A function will be available throughout the program. So please submit questions through that, as well as following the webinar to the presenters. And the presenter contact information will again be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to PowerPoint materials. At this time, I'd like to turn the webinar over to Peter Steinmeyer, and I apologize for the beeping again.
Thank you very much, Sylvia, and thank you to all of our participants and media who are listening in to today's webinar. 2016 was a big year in the area of non-compete and trade secret law, and today we will be discussing what we think are some of the biggest developments of the year. We're going to start out with a discussion of the top 10 reasons why the Defend Trade Secrets Act matters to employers. Then we're going to talk about new state non-compete statutes and the national trend against non-competes for low-wage workers. We're also going to address what courts have been finding dispositive in recent trade secret cases. Talk about what is now adequate consideration for a new or modified compete, the latest regarding choice of law informed selection, and agency developments which impact confidentiality agreements. So with that, let's turn to the Defend Trade Secrets Act. So the Defend Trade Secrets Act was probably the most talked about development in the area of trade secret and non-compete law last year. Got a tremendous amount of publicity when President Obama signed the act into law last summer. In fact, the day after President Obama signed the law, which became effective immediately, one of my colleagues in our D.C. office called me and said, "Hey, Pete, what is the deal with this law? Is it really a big deal, or is it a lot of to-do about not much?" And my response was, well, yes and no. It is a big deal, but it's really not revolutionary. So why should employers care about the Defend Trade Secrets Act? That's what we're going to start off talking about today. The most important reason why employers should care about the Defend Trade Secrets Act is that it creates a private federal cause of action for trade secret misappropriation. That's the single biggest change. Now you've got guaranteed federal court jurisdiction over a trade secret theft case. It doesn't mean that in every instance you're better off filing in federal court than in state court. There may be circumstances or there may be circuits where you are better off filing in state court as opposed to federal court. For example, in Chicago where I practice, we have a dedicated chancery division which is actually excellent in trade secret and non-compete cases, and sometimes we actually choose to file in state court even though we could have filed in federal court. Every case is different. But here, the key thing is it gives you a federal court forum in every case, should you want it, where there's a theft of trade secrets. Related to that, we expect that there will be a development of a federal body of trade secret law. And I think that that will be helpful and useful in terms of giving guidance to companies and practitioners in the years to come, because trade secret cases issued at the state court trial level are not publicly reported, but state secret trade secret cases issued at the federal court trial level are available in Lexis and Westlaw. So I think we'll see a uniform body of law develop. Related there, too, for the purposes of DITSA, it doesn't matter what the value of the trade secret theft is. So you don't have to worry about getting over the $75,000 threshold that you would need to for federal court diversity jurisdiction. If there was a theft of trade secrets, you can now get into federal court. Now, the Defend Trade Secrets Act does not preempt state law causes of action for theft of trade secrets. So, for example, in 48 states currently, every state except for New York and Massachusetts, they've adopted some version of the Uniform Trade Secrets Act. In those 48 states, you still have your state law remedies, and now you also have the Defend Trade Secrets Act remedies on top of that. In New York and Massachusetts, the only two states which have not adopted some version of the Uniform Trade Secrets Act, nevertheless, there are already common law protections for trade secrets, but the Defend Trade Secrets Act essentially nationwide is an overlay on top of the existing state court remedies. Given that, I like to say DITSA remedies plus uniform trade secret remedies means likely to see more trade secret litigation. Although I have to say, since the law was signed into effect last summer, I have not seen any uptick. The only thing I have seen is more of these cases being filed in federal court than state court, although most practitioners anticipate that we will see an overall uptick in the quantity of trade secret litigation now that we have DITSA. Given that we have DITSA, employers no longer need to try and squeeze a theft of trade secrets case into the Federal Computer Fraud and Abuse Act. This is the statute that was enacted to try and protect companies against computer hacking. And so there's been a lot of litigation and a lot of court decisions over the last few years involving what it means to have unauthorized access to a computer system. Essentially, employers were using this statute as a way to try and get into federal court. In light of the Defend Trade Secrets Act, they no longer need to try and squeeze their cases under the Computer Fraud and Abuse Act. In the two states that have not adopted some version of the Uniform Trade Secrets Act, New York and Massachusetts, DITSA changes the law the most. And really the reason why it changes it the most is because now, even in those two states, you can get attorney's fees under DITSA, which you otherwise could not get under state law. So New York and Massachusetts, DITSA has the most change. DITSA authorizes limited employment restrictions based on evidence of threatened misappropriation, provided that those restrictions do not interfere with applicable state law, and provided that those restrictions don't actually prevent somebody from taking a job. So what does that mean in real life? What that means in real life is that you can't use DITSA to prevent somebody from going to work somewhere else. But you can use DITSA to restrict what somebody can do once they go to work somewhere else. So it's kind of, in my view, it's kind of like a limited version of the inevitable disclosure doctrine. Some commentators have said, well, you know, DITSA does not recognize inevitable disclosure. That is true in the sense that DITSA doesn't authorize a complete bar on somebody going to work for a competitor, but it does authorize limited injunctive relief. DITSA also grants whistleblower immunity. Well, what does that mean? It grants immunity under both federal and state law if someone discloses a trade secret in confidence solely for the purpose of reporting or investigating a suspected violation of law to a government official or an attorney. It also provides whistleblower immunity if someone discloses trade secrets in a complaint or other document filed under seal in a lawsuit or other proceedings. So there's limited protection for whistleblowers. DITSA, in one of its most unusual provisions, and one that, you know, kind of surprised me, mandates notice about the whistleblower immunity that I just discussed for you, and any new or updated employment agreement that governs the use of a trade secret or other confidential information. So, why does this matter? What types of agreements does it apply to? Well, for example, it may now apply to a separation agreement if your separation agreement has a clause dealing with confidentiality of information. then DITSA requires that you put in notice about those whistleblower immunities that the statute also provides. Well, what if you don't want to? What's the penalty, or what if you just choose not to, or what if you forget to do so? The only penalty for not complying with DITSA's whistleblower immunity notice provision is that an employer cannot get attorney's fees or punitive damages in a DITSA lawsuit versus the employee. Now, you can still get those very same things under the state law Uniform Trade Secrets Act. So effectively, it's kind of like almost a meaningless penalty, and so I have had some discussions with some practitioners in this area as to whether it's even worth doing it. On the whole, I do think it's worth doing it because it's required by federal law, and there are certainly employers who have contractual obligations to certify that they are in full compliance with employment law, and there are employers who just want to make certain that they do comply with all known federal employment laws. But it really is it's a requirement that essentially has almost at the moment almost a meaningless enforcement mechanism, except in New York and Massachusetts, the two states that haven't adopted some version of the Uniform Trade Secrets Act. Now, the Defend Trade Secrets Act also authorizes ex parte seizure orders in extreme circumstances, meaning that in extreme circumstances, an employer can go into court without giving notice to the other side and get a seizure order and have law enforcement go in and seize stolen trade secrets. So, for example, if you have somebody with a laptop or a briefcase full of trade secrets, they're about to board a plane to flee the country and take the trade secrets with them, you could get an ex parte seizure order in that circumstance. In terms of new non-compete statutes, there were a whole slew of them this year, and I'm going to run through them, starting with sort of the big picture. There's a debate going on across the country today about whether non-competes suppress wages and hurt innovation society-wide, or whether they encourage investment and investment in employees. It's almost a debate between Silicon Valley, where California bans non-competes almost entirely, versus Boston, where Massachusetts has been debating about what to do about non-competes for the last several years and has been unable to decide. But the White House weighed in on this issue within the past year, and I thought it was kind of interesting. It started with a report that the Treasury Department issued last spring, which is based on some research done by Professor Evan Starr at the University of Maryland. And the White House was basically critical of non-compete. So it started with the Treasury Department, then the White House issued its own call to action, which in particular was critical of non-competes for low-wage workers. Where does the Trump administration stand on these issues? We really don't know. I haven't seen any public indication of what the Trump administration is likely to do or whether this is likely to be a priority for them or not. Non-competes are not your typical Republican versus Democrat, blue state versus red state issue. You have the bluest of the blue states, like California. California bans non-competes, as do Oklahoma and North Dakota, two of the reddest of the red states. So it's really not an issue that falls along traditional political lines. It's a little bit difficult to predict the likely involvement of the Trump administration. But again, this is really a state law issue, and what the White House under President Obama was doing was urging states to take action, and they have in fact started to do so. In my home state of Illinois, they passed a law this year that bans non-compete agreements for low-wage workers. Anybody who makes under $13 an hour in Illinois, you can't have a non-compete against them. I would anticipate that this type of legislation will be passed in other states. I think Illinois is on the front line of this issue. The Illinois Attorney General's office, Lisa Madigan, has stated publicly that a high priority for her office is looking into and preventing employers from enforcing non-compete agreements against other types of low-wage workers. So it really is something that employers should be aware of. They should be looking at who they are asking to sign non-competes, and if you are asking minimum wage or low-wage workers or people who shouldn't really have a non-compete, in other words, if you're asking everybody in your workforce to sign a non-compete, it would really be a good time to reconsider that before you draw the attention of a government enforcement authority. Okay, moving across the country to talk about some of the new non-compete legislation. Utah has a law that went into effect on May 10, 2016. It imposes time limits on restrictive covenants, limiting them to 1 year. It also allows employees to recover attorney's fees where an employer seeks to enforce a post-employment restriction which is found to be unenforceable. Alabama codified, well, I say it's a middle-of-the-road approach, but truthfully, when I was rereading my slides in preparation for today, I think it's probably more fair to characterize Alabama's approach as more pro-enforcement really than middle-of-the-road. But regardless of however you characterize it, Alabama has a law that went into effect on January 1 last year that allows non-competes, provided they contain reasonable restrictions. Non-competes are presumptively reasonable if for 2 years or less. The 2 years actually I think is a little bit on the long side in most jurisdictions today. That's why I think the law really isn't quite middle of the road. It's more pro-non-compete. The Alabama law also codifies the concept of equitable modification. In other words, expressly authorizing judges to modify non-competes to make them enforceable rather than striking them down. Rhode Island restricts physician non-competes. It invalidates non-competes and patient non-solicits for Rhode Island physicians. But it does not apply in connection with the purchase and sale of a physician practice if the restricted covenant is less than 5 years in duration. That carve-out from the Rhode Island statute is something that most states have adopted via their common law as well. Namely, in the sale of a business context, courts are much more likely to enforce a non-compete than in other contexts. So I'm not surprised that although Rhode Island has expressly now banned physician non-compete, it did an express carve-out in the sale of a physician practice context. Connecticut also restricted physician non-compete, but not as sweepingly as did Rhode Island. What it does do is it creates certain bright line limits for enforceability in any new, amended, or renewed physician agreement. It allows a duration of up to 1 year and a geographical scope of up to 15 miles from the primary site where the physician practices. Hawaii. Now let me first say, we're listening in from Hawaii. Just know that the rest of us are jealous. We all wish that we were there, but we're not, especially me, the guy from Chicago. Hawaii has banned non-solicits and non-competes for employees of technology businesses. I think this is an influence from Palo Alto and Silicon Valley in California, but it's interesting that they did a specific ban on non-competes focused on the technology industry. Idaho has created a rebuttable presumption of irreparable harm for key employees or key independent contractors. If you are among the highest 5% of an employer's employees, you are presumptively a key employee or key independent contractor. Finally, Massachusetts, as I mentioned at the beginning, Massachusetts for years has been debating whether or not to ban or significantly restrict non-competes. And it all goes back to the debate as to whether non-competes foster innovation or whether or not it stifles it and stifles developments of information and technology nationwide. It's almost a debate between MIT and Stanford, but it's going to be an interesting issue. And again, Massachusetts had the debate this year, and again, Massachusetts failed to enact a statute limiting non-compete. I expect that this discussion in Massachusetts is going to continue. With that, I'm going to pass the microphone to my colleague, Jonathan Shapiro, who's going to talk to us about significant trade secret cases from the last year.
So, the first case I'm going to discuss illustrates the interplay between DITSA and state law. It's called Henry Schein v. Cook, coming out of the Northern District of California from June of this year. Henry Schein markets and sells medical, dental, and vet equipment. Jennifer Cook was a former sales rep of HSI, and she was subject to confidentiality agreement and non-solicitation agreement that would have prevented her from disclosing confidential information and soliciting HSI customers for 12 months after her employment ended. Despite that agreement, she joined a competitor and began soliciting HSI's clients. She also acted badly by emailing herself a large amount of data before resigning, keeping and trying to scrub her company laptop for 2 weeks after resigning, and accessing HSI data from an iPad app after resigning. And HSI then sued in federal court, alleging 8 counts, including a misappropriation claim under DITSA and also a claim under CUTSA, which is California's Uniform Trade Secret Act. The court granted a TRO and then issued a preliminary injunction 12 days later, restraining Cook from accessing, using, or disclosing HSI's confidential, proprietary, or trade secret documents, data, or information. The court found that customer histories were protectable as a trade secret under DITSA, and that Cook took materials using improper means. And that's what's really notable about this case. The court looked at the definition of trade secret and misappropriation under both DITSA and CUTSA and said both define misappropriation as use of improper means, which includes theft, misrepresentation, espionage. So it had the same definition generally under either law, and the court concluded that she misappropriated trade secrets under both provisions. But the court didn't enjoin Cook from soliciting customers because California says that non-solicitation agreements are void where they prevent an employee from engaging in a lawful profession, trade, or business. There is a trade secret exception to that rule, but the plaintiff must prove that the non-compete or non-solicit is necessary to protect the trade secrets at hand. And given that there were separate clauses to prevent Cook from revealing or misusing the trade secrets, it didn't fall into the exception, and the district court didn't enjoin Cook's contact with HSI's customers. So although the court issued the injunction in this case in HSI's favor, I guess you could argue that it's more of a win for Cook because she's still allowed to solicit customers. The next case is Adam Arms versus Unified Weapons Systems from the Middle District of Florida from September of this year, and it interprets the DITSA statute of limitation provision. Adam Arms and United Weapons entered into an agreement not to disclose confidential and trade secret info with the purpose of manufacturing and supplying weapons to the Peruvian government. But behind Adam Arms' back, Unified Weapons went ahead and entered into its own contract with Peru to manufacture rifles using Adam Arms' own rifle technology. Based off of that, Adam Arms sued in federal court alleging 8 counts, including misrepresentation under DITSA. So very similar to the last case I just discussed, the Henry Schein case. Unified Weapons moved to dismiss the DITSA claim, relying on its statute of limitation provision, which states that a civil action may not be commenced later than 3 years after the date on which the misappropriation occurs. It also states that a continuing misappropriation constitutes a single claim of misappropriation. Adam Arms argued that DITSA didn't become effective until May 11th, after the events at issue, and Adam Arms' claim should be treated as a continuing misappropriation. The court said that the statute of limitations provision addresses only when a claim accrues. It doesn't address whether an owner may recover under DITSA when the misappropriation occurs both before and after the effective date. So instead, the court looked to Section 2E of DITSA, which states that it applies to any misappropriation for which any act occurs after the effective date. So the implication there is that when an act occurs after the effective date, a partial recovery is available on a misappropriation claim. The court noted here that Unified Weapons acquired Adam Arms' confidential info prior to May 11th, but disclosed that info to the Peruvian government after May 11th. So the court held that Adam Arms sufficiently alleged a prohibited act after May 11th related to that disclosure, but dismissed it to the extent it was based on United Weapons disclosure, United Weapons acquisition of trade secrets prior to May 11th. The next case is Panera v. Nettles and Papa John's from the Eastern District of Missouri in August. Michael Nettles was Panera's vice president of architecture, and he had a confidentiality and non-compete agreement with Panera, barring him from working for a competitor 1 year after his employment ended, and it specifically listed Papa John's and 28 other companies as competitors, and it viewed Papa John's as a competitor because both were in the quote-unquote food alternative business, which are companies or businesses committed to using the fresh ingredients with minimal artificial components. Nettles requested a waiver from Panera to compete. Panera refused, and then Nettles joined Papa John's anyway in their IT department. So Panera sought a temporary restraining order to enjoin Nettles from working at Papa John's. They argued that Nettles had access to confidential info on his computer and other devices, and that he made a backup of that material on his personal computer, deleted it all, wiping clean his personal computer. So the court said that Nettles may have breached his fiduciary duty to Panera regarding its confidential information. And while Missouri has not formally adopted the inevitable disclosure doctrine, the court relied on it and enjoined Nettles from working for Papa John's, finding a likelihood of success on its contract-based restrictive covenant claim and under Missouri's Uniform Trade Secret Act. And the principle underlying inevitable disclosure is that there's a high probability that the former employee would reveal trade secrets at a new company, so an injunction is warranted to prevent that disclosure. And the court didn't discuss the merits of the DITSA claim here, and that's likely because threatened disclosure rather than inevitable disclosure is a touchstone under DITSA. The next case is Globe Ranger Corp. versus Software AG, United States of America, coming from the Fifth Circuit from September of this year. In this case, Globe Ranger claimed that Software AG misappropriated its radio frequency identification technology, or RFID technology, after taking over Globe Ranger's subcontract with the Navy to implement that technology. And that technology is most commonly used for electronic readers and toll booths like your EasyPass. Globe Ranger won a $15 million verdict at a jury trial based on 5 asserted state law counts, including misappropriation of trade secrets. Software AG appealed, arguing that federal copyright law preempted Globe Ranger's trade secret claim, and the Fifth Circuit rejected the appeal, holding that the Copyright Act doesn't preempt trade secret law because both involve copying, but trade secret laws, of course, protect not just against copying, but also taking through breach of a confidential relationship or other improper means. 10 other circuit courts agree with the Fifth Circuit's holding that trade secret misappropriation is not preempted by copyright law. We're going to start looking at some cases involving some big verdicts against bad leavers or people who left their company under, using bad methods. The first case is Epic Systems Corp. versus Tata Consultancy from the Western District of Wisconsin in April. Here, Epic accused Tata of stealing documents and other confidential information tied to the software it builds for healthcare companies to manage billing. Epic argued, and the jury ultimately found, that Tata reviewed Epic's IP under the pretense of doing consulting work for an Epic client, and they ultimately issued a $940 million jury verdict for Epic, $240 million in compensatory damage and $700 million in punitive damages, and that's obviously a huge, huge verdict. And it's likely what happened here is that the discovery sanction of adverse inference drove that verdict. There were 12 related discovery hearings in the case, and Tata had numerous discovery violations. The court said in one of its rulings that Tata's violations likely prevented Epic from unearthing evidence of Tata's improper use of confidential information obtained from its website. And the adverse inference meant that the judge told the jury it could assume that the evidence from these missing documents or information that Tata was supposed to produce would have been unfavorable to Tata. The defendant's motion for judgment as a matter of law with respect to damages is pending, and the punitives here will likely be reduced to $480 million due to Wisconsin's statutory cap of double the amount of compensatory damages. Another big verdict case is BG Ballmer, coming from Pennsylvania early this year. The Ballmer agency is a Pennsylvania insurance brokerage company. The defendants here were former employees that were subject to agreements forbidding them from soliciting Ballmer customers and active prospects for 4 years after employment. And these former employees, on company time, using company facilities, conspired with their new employer, Frank Crystal, to hire the company's junior employees and to solicit existing clients, including the largest and best clients of the company. And they also compiled Ballmer's trade secret info and brought it to the new employer. So based off of those actions, the judge issued a verdict of $2.3 million compensatory damages and $4.5 million punitive damages, which the Pennsylvania Appeals Court upheld because that's only a ratio of 1.88 to 1. So the Appeals Court here cited the U.S. Supreme Court 2003 State Farm versus Campbell decision, where the Supreme Court had said that a ratio exceeding single digits will rarely, if ever, be permissible, and that a 4 times ratio of punitives to compensatory damages is much closer to the line of constitutionality, so 1.88 to 1 was certainly within the Supreme Court's guidelines. Another big verdict case is Nedstroff Detroit versus Demos Enterprises, coming from the Sixth Circuit in April. It involves more very bad actors. 2 of Nedstroff's employees secretly formed a competing business using their wives' names to do exactly what Nedstroff did, which was service and provide replacement parts for fastener machines. The district court granted summary judgment to Nedstroff, and Nedstroff was awarded $3.7 million and a permanent injunction. The Sixth Circuit Court of Appeals affirmed. And on appeal, the employees argued that they didn't compete with Nedstroff because they only were providing parts and services to customers who had previously requested a quote for the same part or service from Nedstroff, but then had rejected Nedstroff's quote. The Sixth Circuit said that argument ignored both common sense and the evidence. So just remember, barring a contractual limitation, an employee is permitted to take steps to prepare to compete with its employer, but you can't do so while you're still employed, and you can definitely never do so using your employer's trade secret or confidential information. The last case I'm going to discuss is Tesla Wall versus Budd, coming from the Southern District of New York. Tesla Wall is an architecture and construction company. Michael Budd was its former president for 2 years before resigning. He had a contractual provision prohibiting him from interfering with Tesla Wall's actual or potential business relationships for 6 months or soliciting any Tesla Wall employees for 9 months. And despite those agreements, he was accused of organizing a competing curtain wall company based off of Tesla Wall's business plan for future operations and hiring all of Tesla Wall's employees to work for the new venture. The case went to trial, and the jury ultimately awarded Tesla Wall $14.5 million. Obviously, the jury agreed he was a very bad leaver. The defendant filed a motion for judgment or as a matter of law or for a new trial on December 22nd. But the initial jury outcome here of this case and the others we've looked at should serve as a reminder that you really need to weigh the pros and cons and risks of going to trial because you're subject to big verdicts like this. The next topic I'm going to discuss is what is now sufficient consideration for a new or modified compete. The minority rule is that continued at-will employment by itself is insufficient consideration for a non-compete, and I'll discuss the majority rule shortly. Consideration, of course, is the benefit that a party gets or expects to get from a contractual deal. It's usually the result of a promise to do something you're not legally obligated to do or a promise not to do something you have the right to do. So in these minority jurisdictions, what counts as sufficient consideration? Well, there's not been much news this year. One case touched on this issue, XPO Logistics v. Annis from the North Carolina Superior Court in July. XPO and an employee had entered into an employment agreement with a non-compete after the employee had already been working there. And the agreement said that the employer would pay Annis severance benefits during that 6-month non-compete period upon the employee signing a release. The court found that the severance benefits constituted sufficient consideration, and it didn't matter that the employer had the discretion to draft the release because the employer was obligated to do so in good faith. This case recognizes the North Carolina rule that an employer must provide an employee with new consideration for a covenant not to compete once the employment relationship has already commenced. Next case in this area is Durrell v. Tech Electronics from the Eastern District of Missouri in November. Robert Durrell had worked as an account manager at Tech Electronics. He had a non-compete clause in his employment agreement for a period of 1 year post-termination, preventing him from working for a competitor within 150 miles of St. Louis or Columbia, Missouri. And he sought a declaration from the Missouri District Court that his non-compete was unenforceable for lack of consideration because he was only an at-will employee, meaning that the company could terminate him at any time for any reason at all. The employer, Tech Electronics, moved to dismiss his declaratory judgment claims, and in reaching its decision, the court relied on a few recent Missouri cases holding that at-will employment is not valid consideration, in the context of arbitration agreements. The court denied the employer's motion to dismiss the declaratory judgment claims accordingly. And what's interesting here in the twist is that previously Missouri courts have enforced non-competes based on mere at-will employment as consideration. Given the procedural posture that was just a motion to dismiss, it's unclear if the case will have broad impact, so we'll have to stay tuned. So what consideration is necessary for a non-compete in a post-employment severance agreement? New York case, U.S. Security Associates versus Grisanti considered that. It was brought by the U.S. Security Associates against its employee, Douglas Grisanti, who was a branch manager for the company, and they alleged that he breached his employment and separation agreement by going to work for a competitor, even though they terminated him without cause. And the case applies New York law, and the court discussed the Court of Appeals' decision in Post versus Merrill Lynch, which New York courts have construed to mean that non-competes are unenforceable where the employee is terminated without cause. Well, his employment agreement contemplated only 5 weeks of severance conditioned upon a release of claims, but in the severance agreement, U.S. Security Associates provided him with 12 weeks of severance. That additional 5 weeks in the severance agreement allowed the court to distinguish Post because Grisanti was offered more than he was previously entitled. So the implication is that non-competes in the severance agreement requires consideration beyond that which employees would otherwise have been entitled to upon termination. Now we'll talk about the majority rule, which is that continued at-will employment by itself is sufficient consideration for a non-compete. New York and New Jersey are both in this camp, provided that the employer refrains from discharging the employee for a substantial period of time. Well, how much exactly continued employment will suffice? Courts asking this question are seemingly ignoring the well-settled contract principle that any consideration will support a contract promise, because it's the existence of consideration, not the amount, that should be determinative. We asked here at Beefield Redux, and in that case, which was the Illinois First District Appellate Court, they held that absent other consideration, at least 2 years of continued employment are required to constitute adequate consideration for a restrictive covenant. And since then, 3 states, Kentucky, North Carolina, and Pennsylvania, have all issued decisions requiring some consideration beyond mere continued employment. And those 3 decisions mean that more courts are willing to deviate from the so-called majority rule, although the rule still remains the majority for now. The final case I'll talk to you about is Wharton Physician Services versus Signature Gulf Coast Hospital, coming from Texas. In this case, Wharton Physician had entered into a contract with Gulf Coast to provide various hospital services and to coordinate the hiring of individual physicians for Gulf Coast. The term of the contract was 2 years, but could be terminated with 6 months' notice. And it also included a 6-month non-compete clause allowing Wharton to seek liquidated damages if Gulf Coast violated it. And prior to the end of the contract's term, Gulf Coast entered into a service agreement with a new counterparty, and 2 of its affiliated employees had signed contracts with that counterparty. The court ended up holding that the Gulf Coast contractual obligation to pay Wharton for its services constituted the full exchange of consideration, and that the non-compete was unenforceable because there was no evidence of additional consideration for the non-compete aside from the fees paid. And also stated another way, there's no consideration for Gulf Coast's promise not to hire any physicians if the contract between Wharton and Gulf Coast was terminated. And with that, I'm now going to turn it over to Robert Goldstein.
Thanks a lot, Jonathan. I'm going to start by talking a little bit about choice of law-informed selection provisions. All too often, form selection provisions and choice of law provisions don't get the attention they deserve when someone is evaluating an existing agreement with a restrictive covenant or drafting an agreement. It's easy to overlook choice of forum and choice of law provisions because they're usually buried at the back of an agreement. They're commingled with boilerplate provisions, such as merger clauses and assignability, and are often overlooked. But the provisions for forum and choice of law are critically important, particularly in agreements that have restrictive covenants, because it can be the difference between enforcement of an agreement or dismissal of any claims to enforce. The laws above the states can vary greatly with regard to the enforceability of restrictive covenants. California is famously hostile to restrictive covenants, but at the other end of the spectrum, you have states like Florida where restrictive covenants are commonly enforced to the point where a New York appellate court recently called Florida law obnoxious. and refused to apply Florida law. So there are discrepancies among the courts, and it's important to determine when you're drafting an agreement or reviewing an agreement to determine its enforceability that you pay careful attention to those provisions. And in doing so, you can reach a fairly accurate understanding of whether or not the agreement is likely to be enforced. Now, we've got two lines of cases in federal court and in state court that will impact the analysis of forum selection provisions and choice of law provisions. With regard to federal court, the law has recently become much more clear than it has ever been. There was a discrepancy and a little bit of uncertainty among federal district courts until recently regarding the proper standard for enforcing a forum selection provision. You have the 1972 seminal case of Bremen v. Zapata, which essentially said that forum selection provisions are prima facie valid and district courts are to enforce them absent very unusual circumstances. So if an employer in federal court has a non-compete that designates a state that is favorable to non-competes, that provision under Zapata would be enforceable absent unusual circumstances. But then you have another case in 1988, Stewart v. Rico, where the consideration of enforceability was really left a lot more gray. In that case, the Supreme Court said that the enforcement of a forum selection provision is really just one factor in an overall 1404 analysis for transferring venue. So that left a lot of discretion to the judge in terms of whether or not to enforce a forum selection provision. So there was some degree of uncertainty. That has now been removed. The Supreme Court in Atlantic Marine Construction versus U.S. District Court has ruled that non-compete provision, choice of law provisions and choice of provisions in non-compete agreements are enforceable, and only in the most unusual cases would a district court be permitted to disregard a choice of forum provision. What's, I think, particularly important about the Atlantic Marine decision is the circumstances when a district court is permitted to disregard a forum selection provision cannot be related to the convenience of the parties. The convenience of the parties is not a factor. The only basis that an employee would have to disregard or persuade a court to disregard a forum selection provision is if the public interests outweigh the party's designated forum. That is a very high threshold, and it's much more likely than not that a district court is going to enforce a forum selection provision, even in states where restrictive covenants are disfavored, and the forum selection provision requires the matter to be litigated in a more receptive state. Now, it's also important to note that the Supreme Court did not completely close the door on challenging a forum selection provision. There are still circumstances where the state's public policy can be taken into account and public interest issues can be taken into account. So there's a small window there. But in general terms, if you're in federal court, you are much more likely under Atlantic Marine Construction to get a court to enforce your forum selection provision. But of course, that's federal court, and not all disputes over non-competes and restrictive covenants can be in federal court, either because there's no original jurisdiction or just for strategic purposes, parties proceed in state court. Under state law, in most states, forum selection provisions and choice of law provisions are generally adhered to and honored by courts, as long as there's some connection between those provisions and the parties. Typically, the nexus between a choice of forum provision is satisfied if it's designating a state where the employee works, where the employer maintains its headquarters, even where the employer is incorporated, can generally be viewed as a sufficient basis for enforcing a forum selection provision. But we still have states that will reject a choice of law provision if the public policy is sufficiently strong. And California is the most important example of that. I think most people are aware of how disdainful California courts are towards restrictive covenants of any kind, and that's seen in their statutory prohibition under 16600. What has happened recently, though, is that California has doubled down and closed what I thought of as a little bit of a loophole under California law until recently. That loophole is that while California courts will generally not enforce a choice of law provision that designates the law of another state if it's contrary to California law, they were, in some cases, willing to enforce a forum selection provision. So if you have an agreement which provides for New York law and a New York forum, there was a good chance that you could persuade a California court to honor the forum selection provision, even though it would result in a transfer to a state that would enforce the restrictive covenant. It was a somewhat anomalous situation in California where, you know, they would bend over backwards to prevent employers from enforcing restrictive covenants by using another state's law, but they didn't have as much of a problem kicking a case to another state if the agreement had a forum selection provision. Now, we've seen California over the past couple of years try and tighten that loophole and eliminate it. There was a recent case where the court held that a forum selection provision will not be enforced if it deprives an employee of a non-waivable statutory right. So if a forum selection provision provided for an employee to litigate in New Mexico, and New Mexico did not provide the same statutory right that the employee was entitled to in California, the forum selection provision would not be enforced. But California legislators have gone one step further, and as of 10 days ago, the law in California now includes California Code Section 925, which provides an absolute prohibition on employers requiring employees to agree to adjudicate a dispute outside of California or to agree to the substantive protection of the laws of another state. There's one exception to that prohibition, and that's where employees individually have individual representation by counsel when they negotiate the agreement. Now, as we all know, that doesn't happen very often unless you're talking about the most senior level employees who have independent counsel. So I don't think that exception is going to play a huge role going forward. But the other important thing to note about the California statute is it is prospective. It's not retrospective. So agreements that were executed prior to January 1, 2017 are still going to be subject to California law as it existed when the agreement was enacted. Now, that does not mean that an agreement with a forum selection provision that's covered by this, that predates this agreement, is going to be enforced. California law is not changing as a result of this provision. So even if you're not covered by the statute, if you have an agreement that predates the statute, it's going to be, or the substantive law is going to be the same as it will be for agreements after the enactment of the statute. Section 16600 is going to prohibit non-competes regardless of whether the non-compete was signed before or after January 1, 2017. The only change that's really going to be effective after now that this statutory provision is in place is that there will be no opportunities or very, very limited opportunities for an employer to persuade a California court to transfer a case to another state. So in those cases, you're going to be stuck in California, and the California court is going to do what it's going to do, in most cases, rejecting a restrictive covenant. There are still avenues that an employer can pursue to try and avoid the limitations in California, but they're a lot more risky now and really need to be thoughtfully considered before an employer takes these actions. For example, an employer could file an action against a California employee by pursuing a claim in, for example, New York, if the agreement has a New York choice of law and a New York forum provision, even if the employee is in California. And a New York court, at least prior to this California statute, would honor the choice of law and the choice of forum provision. I think that we're going to see that happen much less going forward. Now that there's a statutory prohibition in California against these provisions, I think we're going to see New York courts or courts of any other jurisdiction being much more reluctant to enforce a restrictive covenant that's governed by the law of another state against a California resident. I think even more important than that is that pursuing an employee pursuant to a forum selection provision that designates another state, a state other than California, could give rise to an action by the employee in California challenging the choice of law and choice of forum provision, and also becoming entitled to injunctive relief as well as attorney's fees. So if an employer tries to enforce a restrictive covenant by proceeding in the court of another state pursuant to a forum selection provision, that is not going to prohibit a California employee from simultaneously going to a California court seeking an injunction against the enforcement of that provision and seeking attorney's fees. So that risk is there. I think it's something that has to be taken seriously. And going forward, to the extent that you have California employees who are subject to restrictive covenants, I think it would be wise to review those agreements and determine whether or not they're consistent with the California statute. Now I'd like to turn just briefly to agency developments and the impact that they have had on confidentiality agreements. We've seen a trend over the past few years, starting with the EEOC, but also including the SEC and the NLRB, of challenging agreements with employees that have confidentiality provisions, non-disparagement provisions, and similar provisions. The EEOC, for example, has challenged confidentiality provisions in severance agreements to the extent that they believe those agreements contain confidentiality provisions that could prevent employees from proceeding with filing a charge to a governmental agency. So what they've required is for agreements to contain very clear language that says nothing in that agreement will prevent employees from exercising their right to file a charge. But even when employers put that provision in their agreement, there have been cases where the EEOC is still not satisfied if the language is not sufficiently clear, and the EEOC believes that there's still an opportunity for an employee to believe that he or she can't file a claim with an administrative agency. I think we're going to see a potential change in the EEOC's treatment of these provisions. They've been very aggressive, but they've not been particularly successful in pursuing their claims against these confidentiality agreements. In one case, a case was dismissed for technical reasons, and in another case, there was a EEOC, the College America, the EEOC challenged a provision that had the same type of provisions that the EEOC disfavors, but the jury ruled against the EEOC in that case. So the EEOC has still maintained that it is skeptical and disfavors agreements with confidentiality provisions that could restrict an employee's right to file a charge, but I think we're going to see a little bit less of that, and with the new administration coming in, that will also play a role, and it remains to be seen how the new administration will handle this. But the EEOC is still pursuing these claims. It's just not been particularly successful yet. The same is true with the SEC. They've also been pursuing claims against confidentiality and similar agreements in employment agreements, separation agreements. The interesting thing about the SEC is they've taken a more aggressive approach than even the EEOC. In the SEC v. Blue Links Holdings, they not only rejected the provision, the confidentiality provision, they rejected the employee's waiver of a right to a monetary recovery, which some employers had put in those agreements to ensure that while an employee can still file a charge under the agreement, they're not going to be permitted to seek money damages because the monetary relief has already been provided under the settlement agreement. The SEC has rejected that and does not permit employers to require employees to waive their right to monetary recovery. It remains to be seen, again, whether or not the SEC is going to continue taking that aggressive approach. We also have the NLRB, which has also been pursuing claims against confidentiality policies and agreements, basically for the same reasoning as the EEOC and the SEC. I think the takeaway is that language should be included in all separation agreements, employment agreements, or any other agreement that requires employee confidentiality to be careful to include the right kind of language, the specific language, make it clear that nothing in that agreement will prevent an employee from pursuing a charge or a claim with any government agency. As long as there's sufficiently clear language making that point in employment agreements, the risk is much lower that you will encounter difficulties with a governmental agency. And again, going forward, we'll see how the new administration handles this and whether these agencies are going to continue to be aggressive or start backing down a little bit in terms of their enforcement.
Thank you, Robert. We've concluded the formal part of the presentation, but we are happy to answer any questions that anybody may have. We can answer a few that have already come in, and if any of you have any other questions that you'd like to address, feel free to reach out to Dr. Robert or myself. We'd be glad to talk to you. First question we got was, are there any judicial trends regarding the enforceability of non-compete that are noticeable nationwide? Really varies state by state because non-compete law is so state-specific. But I would say on the whole, what we are seeing is where courts are most likely to enforce a non-compete is where you have not only a non-compete violation, but some further bad acts. You almost have to be a bad leaver, not merely violating your non-compete, but you almost must have stolen something. So if you are a thief and you violated a non-compete, you're going to have an issue. If you've merely violated your non-compete, I think a court is a lot less likely to take enforcement action. Another question we got. What law was applied to trade secret claims before the Defend Trade Secrets Act? Before the Trade Secrets Act, employers had to rely entirely on state law. In 48 of the 50 states, every state but New York and Massachusetts, the state had adopted some version of the Uniform Trade Secrets Act. In New York and Massachusetts, employers relied on the common law. So today, all of that state law remains in place. There's now just this overlay of DTSA in addition to state law. We got a question about Illinois statute banning non-compete for wage workers. The question was, under Illinois law, how are non-competes being defined? statute says that a covenant not to compete means an agreement between an employer and a low-wage employee that restricts such low-wage employee from performing any work for another employer for a specified period of time, any work in a specified geographical area, or any work for another employer that is similar to such low-wage employees' work for the employer that is not a party to the agreement. Also got a question under the Illinois statute banning non-compete for low-wage workers. Does the statute also cover client and customer non-solicitation agreements? No, it does not. It only covers pure non-competes, although odds that a judge would enforce a customer non-solicit against a low-wage employee are very low. However, a court would enforce a confidentiality agreement against any employee, because no employee has the right to steal their employer's information. That's really true as a matter of common law or to the Uniform Trade Secrets Act. Those are all of the questions that we have received, but again, if anybody has any other questions that they would like to ask, that they think after the program is over, feel free to reach out to any of the three of us, and we would be glad to answer your questions.
This concludes our webinar. Again, we're sorry for the technical difficulties of the beeping. And in approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. Thank you to our speakers, and thank you for calling in. Have a great day.